Srihari. I'm doing internship at LEXIS and Company. Today my topic is wrongful restraint and wrongful confinement as per the section in IPC. It comes under the category of offence against human body. If you can see in the barrack, if you open, there you can see the subheading wrongful restraint, wrongful confinement. So why should I choose this topic? Basically, most of the students are confused about wrongful restraint, wrongful confinement, what it means. So I would like to explain with one of the case law with state of Jammu Kashmir or Bhimsing that I would be explaining after explaining what is wrongful restraint and wrongful confinement. So wrongful restraint means what? Going to our barrack section 339 of Indian Penal Code, that is IPC, talks about what is wrongful restraint and what is wrongful confinement. Coming to section 339 of the Indian Penal Code IPC, where it talks about wrongful restraint. First, we will read to the section barrack. It means it talks about whosoever voluntary cause to subtract any person from proceeding in his direction in which he has right to proceed is called as wrongful restraint. So in this, it mainly talks about two essential. One is that any person who voluntarily obstructs. Second is that a person who has right to proceed but he is stopped by the person is said to be wrongful restraint. For example, if Charu is walking on a public road and she has right to pass, one of the other person comes and obstruct that person. Charu saying that you have no right to pass. Here, Charu is prevented from her own path for proceeding, that is a wrongful restraint. So here the person who has been stopped Charu has said to be done a wrongful restraint. Whereas in a wrongful confinement it is totally different. If you talk about section 340 of Indian Penal Code, that is wrongful confinement. In this wrongful confinement, it talks about whosoever restrains any person from such a manner to prevent beyond the certain limit that he has. It says that whosoever restrains any person that prevents from a certain line which crosses beyond its limit is said to be wrongful restraint. For example, if B goes to Z within a wall space, then Z is being it says that if A causes Z to go within a locked space and Z is being locked, A thus prevented from the direction beyond the certain prescribed limit, a wrongful restraint confers on Z. This example talks mainly that if Z is going for some phase and he has been locked with the A, so A has done one is wrongful restraint that preventing from doing present direction. Beyond that, he has also locked him in the room, that is beyond the certain type of limit. It's called as wrongful confinement. So main thing in these two aspects is a wrongful restraint, that we are stopping a person going from a wrongful in a direction. For example, if you are going to write an exam hall and somebody stops you without no reason, that it's a wrongful restraint. Person who has been stopping you has right to path. We can bring the one of the article in this concept also, article 20 or 21 I seems, that's related to right to life and right to liberty, where we have right to life with dignity, freedom, that has been affected. So that is for wrongful restraint. But wrongful confinement is different, where you are stopping the person proceeding in a direction, also you are doing an act with it beyond the limits. It's called as wrongful restraint, wrongful confinement. So we can explain this with one of the case law that we have, as I said, that is state of Bhimsing versus Jammu Kashmir. This is one of the case law where we learn in the law of torture of false imprisonment basically. So coming to the facts of the case, that is state of Jammu Kashmir versus Bhimsing, you can search in it, you will get it with facts and analysis. So here the case was that one of the MLA was being going to the parliament for the assembly for the meeting, where he was being stopped by a police officer, and this person who should supposed to be in a parliament for an assembly meeting, where he was filed with an FIR for sedition and inflammatory speeches public meeting as per section 153A of Indian Penal Code. So here there was also a voting session assembly where he should be there, but he was not there, he was not allowed to go basically, and where his vote was very crucial, but the person whom it was detained was the police. So here the Honorable Supreme Court also noticed one of section that he was not found till 13th September, and the court ordered the police officer to produce before him. So for producing the before him, there's one of the writs that we have in constitution, that is known as the habeas corpus, where we should produce a person before 24 magistrate court. So this is what here one of the issue which was raised is that whether it was false imprisonment. It's false imprisonment, I mean, because here the police officer acted in a wrongful direction where he stopped the MLA from not proceeding stopped him proceeding from to the assembly polls, and he had done act which is certain beyond its limit by detaining him for 24 for detaining him for 2 or 3 days, where he was he should be in there for magistrate for 24 hours by the police, but the police did not kept him not kept him. He did not go to the police did not bring him to the court for 24 hours. He was kept in detention. So the police was arrested with the false imprisonment with the mischief and the mischief intent, that it was clearly intention is the gross of violation of the fundamental right we have in our article 21-22. Here one of the specialty of this case is that mainly it is one is that wrongful confinement. We can clearly see in the facts if we read. Second is that they have been embedded the article 21-22 of the constitution, saying that right to life and right to liberty. So here one of the argument that was put in forth before the court from the respondent side was that the petitioner the inspector of general police was one of the person who contacted on 10 September 1985, where he put a notice to superintendent police station arrest Bhim Singh after 2 days. So the police got a headquarters instructed to give proper food and facilities, and they started petition brought in a police station at brought to a police station 9:35, and the officer were put in place into attention that he can travel safely, and region that also contained on 11 September 1985. So this was the one of the facts, the arguments that are put. Why I think for in my aspect, in legal aspect, I think he's been violated. The police officer has been violated his rules and regulations as per in the section 3 as per section 340 of wrongful confinement, where he had acted on his beyond its certain type of limits that can be said in wrongful confinement. And the two articles, that is as article 21 and article 22, talks about where right to life, liberty, where he has stopped the he has violated the constitutional right of an individual for also for arresting him. Basically this case is more of a false impression, but we can also bring it into wrongful confinement also. This is one of the legal aspect that I can put in forward in case for my case analysis in this aspect. So if you have any doubt, you can comment. If you like, please share, subscribe. This video is only for the educational purpose. Thank you. Bye.